When you overstay your I-94 card period that is granted to you when you enter the U.S., you start to accrue unlawful presence, which is not forgiven when you are married to a green card holder or permanent resident. You could be barred for 3 or 10 years, depending on how long you've stayed in the United States, if you leave to obtain a visa at a consulate abroad. If you're here unlawfully present, you're not eligible for a visa or to file a green card case in the United States if you're married to a permanent resident. But you would still be subject to the unlawful presence bars the minute you left the United States to go pick up your visa at the consulate abroad. Unlawful presence is very serious, and you should really track how long you've been in the United States before you make any travel moves or visa applications. Similarly, it's a big mistake to overstay your voluntary departure grant. Voluntary departure is a special type of relief available in immigration court, where the judge allows you to return to your home country, usually within 60 days, and you do so voluntarily, and without the government paying for your plane ticket. The judge gives you this instead of a removal order. Voluntary departure would then allow you to reapply for a visa from abroad without having a removal order. Otherwise, a removal order could keep you outside the United States for 10 years. Many people like the idea of getting voluntary departure because it sounds better than a removal order, but they don't fully understand the consequences of overstaying the voluntary departure grant. They just don't leave the United States. When you overstay a voluntary departure order, you are ineligible for applying for a green card in the United States for 10 years. You're also ineligible for cancellation of removal and other forms of common immigration relief in that 10-year period. Your voluntary departure grant also automatically turns into a removal order when you overstay it. So not only could you face an unlawful presence waiver, but you could also have to file a discretionary application to come back to the U.S. prior to the 10 years that your removal order dictates you stay outside of the United States. But the more recent your exit from the United States for interviewing for your green card at the consulate and having to apply for this discretionary relief, the more difficult it will be for the case to be approved, and you could be separated from your permanent resident spouse for many years. I am an expert in complex family-based immigration cases and have a 98% approval rate for the past 12 years. I am a nationally published immigration author and frequent public speaker on immigration topics. I regularly train other immigration lawyers on complicated marriage and family immigration cases for the American Immigration Lawyers Association, Federal Bar Association, and National Legal Education Providers. I represent clients all over the U.S., traveling to immigration interviews and deportation proceedings. Visit our website, humanrightsattorney.com, for more in-depth information and articles on complex family immigration issues.